this morning. That is 126789, State of Kansas versus Quentin Kirk Lawton. Would the parties state their appearances, please?
Good morning, Your Honors. Emily Brandt of the Appellate Defender Office here on behalf of Quentin Lawton, the appellant, present and ready for argument. I would request 5 minutes of rebuttal time this morning.
Thank you.
Good morning. May it please the court. The state appears by Deputy District Attorney Jody Liffin.
Okay. Again, you're both people that have appeared before us numerous times. You know the drill. So, Miss Brandt, why don't you go ahead and get started, and y'all have 5 minutes for rebuttal.
All right, may it please the court. There are two issues before this panel today. The first being whether or not notice is required to convict someone of trafficking in contraband under KSA 215914A3, as it is under subsection A1. And the second, whether or not Quentin received that notice. Here, the state has conceded that notice is an element of the crime. So unless the panel has questions about that, I thought that I would focus my time this morning on the second issue. Did Quentin receive fair notice? Quentin says no. He'll concede that after the Kansas Supreme Court's recent opinion in State v. Hinestroza, that he's not entitled to individual notice, but he is still entitled to fair notice in order to be convicted of trafficking in contraband. And here, as you are all well aware, this court is not a fact-finding court, and we have here a fact finder who held that there was no notice. The fact finder specifically says that while he's considering, the fact finder here is the judge, this is a bench trial. Now, I have to suspect that there's probably on the wall in the jail, when you're booked in, it says it's illegal to possess drugs inside the jail. But I don't have any evidence of that. I have to imagine that if an individual booked into the jail were given a hard copy of the handbook, there would be a record that they'd have to sign off on it, that they got it. But I don't have any evidence of that either. But the issue is not notice. So I think we have the fact finder here making it very clear that he didn't believe that notice was required to convict Quentin of trafficking in contraband. But if notice had been an issue, he would have acquitted Quentin of the offense because there wasn't any notice. And he says as much at sentencing as well when he's considering Quentin's motion for a judgment of acquittal. He says, the evidence was that not every inmate in the Shawnee County Jail was given a copy of the policy and procedure manual. It's
Counsel,
just yes,
may I interrupt you, please?
of course.
Is it your argument then that the essentially making negative findings here?
I guess that would be correct, Your Honor. The district court judge, who is the fact finder in this instance, is making a finding that there was no notice. But the fact that there was no notice is irrelevant to whether or not Quentin can be convicted, because under his interpretation of the statute, which is based on Pick's comment, that notice wasn't required to convict. So absent notice, he could still convict Quentin of trafficking in contraband.
So I'm going to talk a little bit about what it means to have fair notice. It strikes me that it is, whether you are in a jail or outside of a jail, it is illegal to traffic K2. Would you agree?
Well, I would agree that it's illegal to possess K2, regardless of where you are. I would not agree that it's illegal to traffic K2 into a jail unless you have notice of it, but...
All right, so that gets to my question, and that is, if we're talking about, if it's not individualized notice anymore, if it's just fair notice, then isn't it safe to say that people have fair notice that if you can't possess or traffic something outside of jail, you also can't possess or traffic it inside of jail? It's not like when you go to jail, suddenly, all the rules are off unless they tell you otherwise.
This is true, Your Honor. However, although I don't believe individualized notice is required, which is a standard that Taylor set forth, I think that Taylor is still good law on the issue that the legislature completely gave jail administrators control over what is and is not contraband within their facilities. The trafficking and contraband statute used to have a laundry list of items that were considered contraband, but in 1997 they amended the statute to get rid of it, and so they have completely delegated authority to jail administrators to define what is contraband. And so it doesn't actually matter if the item possessed in jail is also illegal to possess outside of the jail.
I want to stop you there, though, because Watson involved contraband or possession of 10 cigarettes. And outside jail, it's not illegal to possess 10 cigarettes. Hinestrosa involved the possession of a gun, and absent some kind of felony conviction or something along those lines, outside of jail, it's not illegal to possess a firearm. So isn't it different here where we're talking about something where it is illegal to possess or traffic outside of jail? Isn't there something that can be said, as the district court did, and that you don't have to have additional notice? If it's illegal outside of jail, then it's illegal to traffic inside of jail.
Your Honor, I really don't think so because, Taylor very explicitly says, and again, we're talking about marijuana in Taylor, and so we are talking about something in Taylor that is illegal to possess or traffic, et cetera, outside of the jail, and makes it very clear that because total control has been given to jail administrators to define what is contraband, it's not relevant whether or not the item possessed is illegal to have outside of the jail. The administrators of the jail must give people notice about what is contraband inside of it.
Just a second, counsel. Are you arguing then that the administrator of a jail could make it okay to have heroin in there because that's their discretion? Is that your argument? They could make it okay to possess that in jail when they couldn't possess it outside of jail legally?
I think that if the legislature wanted people to not have any drugs in jail, they could have continued to define contraband within jails via statute, and they didn't. So it's totally at the discretion of jail administrators, and absent some indication here that that Quentin knew that he couldn't have drugs in the jail because it was specifically defined as contraband within the Shawnee County Jail, there's no notice.
Is there anything that you, counsel, or Mr. Lawton has relied on to think that that you have to have additional notice other than the fact that you couldn't possess it outside of jail, that somehow was he led to believe that he could possess it?
There's nothing in the record that says he was led to believe that he could possess it, but it's also not Mr. Lawton's burden to put on evidence that he was on notice. So there's no rebuttal that I actually was told I could have K2, so you can't convict me of this. The state had the burden of putting on notice that he knew he couldn't, and they didn't. So there's insufficient evidence to convict him of this crime. He doesn't hold any burden here. Additionally, I would like this court to consider the fact that even when we're in sufficiency land, this court doesn't reweigh evidence or make credibility determinations. And really, I feel like the shoe is kind of on the other foot here, because that's essentially what the state is asking you to do, is to credit one jail lieutenant who, not involved in the booking process, doesn't appear to upload handbooks to residents' tablets, doesn't provide residents with physical copies of the handbook, never gave Quentin Lawton his tablet or knew whether or not he had a physical copy of the handbook. I mean, they're essentially asking this court to say, well, the fact that one lieutenant said that the handbook said X, that's enough that Quentin was on notice. But we have a finder of fact here that says Quentin wasn't on notice. And I don't think that this court should be wading into credibility of one jail lieutenant, particularly when we have another jail officer who says, residents didn't get copies of the physical handbook with any consistency. I also didn't book Quentin into the Shawnee County Jail. I have no idea what was on Quentin Lawton's handbook. Nobody entered the handbook into evidence. So we just We don't know what the handbook said explicitly was and was not contraband. There just simply is not any notice here that Quentin couldn't possess K2 or synthetic marijuana while he was in the Shawnee County Jail, regardless of whether or not it's illegal to possess while outside of the jail. So unless this panel has any other questions, I'll save the remainder of my time for rebuttal.
Any other questions from the panel?
None from
Okay.
me.
No,
All
thank
right.
you.
Uh-huh. All right, you may proceed.
Thank you, Your Honor. Good morning again. May it please the court. The state's position here is that we did provide, or there was sufficient evidence here to convict the defendant of the crimes the crime in this case. First of all, I'll start out with our position that we disagree with the district court's, with what the appellant says that the district court found about notice. Again, as opposing counsel has read, the court basically found two things: that there's probably signs on the wall in the jail that talk about how it's illegal to possess drugs, but there wasn't any evidence of that here, which we agree there wasn't any. And there was probably some sort of record when a defendant is given an actual hard copy of the handbook, and the judge didn't have that here either. But I'll go ahead and read the next sentence. But to me, the notice is not one of whether the defendant was placed on notice that it was illegal for him to possess illegal drugs. The issue was whether he possessed illegal drugs in the jail, and that was done without the permission of the folks running the jail. So in context, in the totality of the district court statements here, I believe the district court was saying, I didn't have evidence of a sign. I didn't have evidence of when he actually got a physical handbook, but that's it. The evidence isn't whether he's allowed to have drugs in the jail. It's whether drugs are considered contraband or without the permission of the folks running the jail, and that's what he had. So our position is that he didn't make a finding that there was no notice. And as I think we all agree now, post Hinestrosa, we just have to have fair notice. And as Judge Warner, you were saying, I think it's fair to say that it's fair notice that you can't, if marijuana K2 is illegal outside jail, you also can't have it inside the jail. So I think that's
So basically what you're asking us to find is that as a matter of law, notice will be presumed if the item is illegal outside of the jail.
I think this court could hold that. I also could think just in the circumstances, fair notice when something's, yes, illegal outside, that's fair notice that, persons of common knowledge, I had it written down somewhere in my brief, whatever Hinestrosa said exactly, persons of common knowledge would know that.
Well, and we don't allow, we know the adage, ignorance of the law is no excuse. So if someone outside of the jail doesn't realize that synthetic marijuana is not illegal, that would not be a defense for them in their criminal charge.
Correct.
Right.
And I think additionally here, if this court wants to go further, I think that in my brief, I outlined the other evidence that the state did put on. I think Lieutenant Biltoff testified that every single inmate was given both a physical copy of the inmate handbook when they were dressed in, as well as a digital copy. Although he didn't specifically give this inmate either, he did say that every inmate was given one. The defendant himself admitted that he had a tablet, and Lieutenant Biltoff and at least one other officer testified that the inmate handbook was on the tablet, and that the handbook stated that inmates are not allowed to smoke or introduce contraband or possess dangerous contraband, which includes smoking materials or drugs. So I think the court did have enough here. I think you look at this in the light most favorable to the state, which is something to remember as our standard of review, and that this court can uphold the conviction here and find that there was sufficient evidence presented by the state. And I don't have any further presentation unless there are any other questions from the court.
No further questions? Okay, thank you. Rebuttal, Ms. Brandt?
I'll address just a couple of things. First, I want to address Hinestrosa's use of the term common knowledge. In Hinestrosa, we have a defendant who admitted that they knew that they could not have a weapon inside the jail. And so people of common knowledge would know that a gun is a weapon. So she knew she couldn't have a gun within the jail. The same thing is seen in Garcia, which is the unpublished case we relied upon. He admitted that he knew he couldn't have drugs in the jail, and he had marijuana. We don't have any admission from Quentin here. You can't impute common knowledge of anything to him. We're not making some inference from, well, you
Why
said,
can't you impute common knowledge to him?
because I think it's just a different factual scenario than the other cases where we're saying, well, you based on common knowledge, you knew you couldn't have a weapon, and common knowledge tells us that the guns are weapons. But here,
Because you had a two-step process that you had to go under there, that a gun is a weapon, and here there's only one step. Drugs are illegal. Drugs are illegal outside the jail. Wouldn't it then be common knowledge that drugs are illegal inside the jail?
Your Honor, I don't think so. Again, because we
Okay.
have in Hinestrosa, we have a defendant admitting that they knew something was contraband. And so common knowledge says that a gun is a weapon. You knew weapons were contraband, so you knew you were bringing something in you couldn't have. Here, again, we don't have any evidence, and besides one lieutenant's testimony about what a handbook that wasn't admitted into evidence says, that residents of the Shawnee County Jail can't have drugs. We don't have Quentin saying, I knew I couldn't have drugs. And people of common knowledge would know that K2 or synthetic marijuana are drugs. So you knew you couldn't have the K2, Quentin. We don't have that here. Quentin never admitted that he knew he couldn't have drugs or admitted that he knew drugs were contraband, etc. And again, I disagree with the state's contention that there was notice in her narrowing of the district court's findings here. Again, I think when the district court says notice is not the issue, it's whether he possessed drugs in jail without permission of jail administrators. But that's not true. Notice is the issue. Of course, if notice is not the issue, then I can say that Quentin possessed marijuana without permission of jail administrators. But because notice is required, he's not finding that he has notice here. And again, I understand the state, letting this court know that when we do sufficiency, we look at the evidence in light most favorable to the state. But I just think it's just different here when we have a fact finder saying, I'm not finding notice. And for us to then go back and reweigh the evidence, because did that lieutenant testify about what the handbook may or may not have said? Yes, but he also testified that residents would be let into the Shawnee County Jail without ever receiving a copy of the handbook. They weren't just going to turn people away. They weren't going to say, oh, we can't book you in. We didn't give you a handbook. They would book people into the Shawnee County Jail without a physical copy of the handbook, without a digital copy of the handbook. Nobody could testify when they started putting the handbook onto tablets. Nobody entered Quentin's tablet into evidence to show that it had a copy of it on there. I mean, we don't have, frankly here, I just don't think there's any evidence of notice. And I don't think it's fair to say that because drugs are illegal outside of the jail, that they're illegal inside of the jail, particularly when the legislature has made the choice to totally abdicate authority to jail administrators to say what is and is not contraband within their facilities. And we have no testimony from the jail administrator here. We had testimony from the jail administrator in Garcia, specifically about what was and was not allowed within his jail. We don't have any of that here. We have two random jail employees from the Shawnee County Jail who are not involved in book-in, who did not give Quentin a copy of the handbook, who did not enter the handbook into evidence. There's simply no notice. That Quentin was simply on no notice, not fair notice, not individualized notice, not adequate notice, that he could not possess K2 while he was in the Shawnee County Jail. And for those reasons, I think this court has to reverse his conviction. So unless this panel has any other questions, I'll cede the rest of my time.
Any other questions from the panel?
I have none.
Okay, thank you both very much. We appreciate your argument today. We will get an opinion out as soon as possible, and be safe out there.